Imagine this. You're 72 years old. You've lived in your home for 31 years. The mortgage is paid off. Your children grew up in those rooms. The walls hold birthdays, holidays, arguments, laughter, and the quiet years in between. Then one morning you have a stroke. You survive, but you can't speak. You can't sign your name. You can't make decisions. You can't answer questions the way banks, hospitals, and government offices require. Your daughter does what most good daughters would do. She rushes to the bank to pay your property taxes before the deadline because she's trying to protect the home you worked your whole life to keep. And the bank looks at her, almost kindly, and says, "I'm sorry, you don't have legal authority over this account. We can't let you do anything." No access, no payments, no transfers, no repairs, no refinancing, no selling, no way to stop late fees or a tax lien. The bills keep coming, but the family's hands are tied. That moment, standing at a counter, realizing love isn't enough to act, happens to families every day. Not because they didn't care, but because a few simple documents were never signed while there was still time. And that's what today is about. The 5 documents that protect your home, your money, and your family's ability to help you before a crisis turns your life into a court case. This isn't internet rumor, it's not fear for clicks. These are basic legal and administrative realities supported by guidance from official sources like the Consumer Financial Protection Bureau, Medicare Information Resources, the Social Security Administration's own rules about benefit management, and IRS rules on home ownership and capital gains. Stay with me to the end because the last item contains a tax trap that quietly costs families tens of thousands, and in some cases, hundreds of thousands, depending on one single decision seniors make about their home while they're still living. Before we get into the list, I want to show you how real this becomes with a story that looks ordinary until it turns into a disaster. There was a man, let's call him Robert. He was 67, retired, owned his home outright. Not wealthy, not struggling, just a regular American who did things the way he was taught. Work hard, pay bills, raise kids, keep your house. He had Social Security, a modest pension, and a savings account. And he had a simple plan he shared at the dinner table. The house would go to one child who lived nearby, the savings would go to the other. Everyone nodded, everyone agreed, everyone believed the conversation was the plan. But nothing was written down. No will, no durable power of attorney, no transfer on death deed, no trust, no clear authority for anyone to act if Robert couldn't. Then he fell, a serious head injury, a bleed on the brain, and suddenly he wasn't Robert who handles things. He was Robert who couldn't make decisions, couldn't sign, couldn't speak clearly, couldn't manage his own life. One child went to the bank to pay the property taxes, stopped immediately, no authority. They called to manage benefit issues, stopped, no authority. They tried to get repairs done to keep the house from deteriorating while Robert was in rehab, stopped. No one could legally sign contracts on his behalf. Then the situation turned ugly, the way grief and pressure often do. The other child filed for guardianship through the court. Lawyers got involved, competing opinions appeared, emotions became evidence, the court became the decision maker. And while the family fought, the house sat empty. Taxes went unpaid, fees grew, a lien threatened. The home that was supposed to be a gift turned into a liability. This is the part people don't understand until they live it. Without the right documents, the system doesn't care that you're someone's child. The system cares about legal authority. And if you don't have that authority, the system forces you into court. So here are the 5 documents that prevent that scenario. 5 documents every homeowner over 60 should have in place while life is still normal. The first document is a durable financial power of attorney. If you only do one thing after watching this, do this. A durable financial power of attorney allows you to name a trusted person, your agent, to handle financial matters if you become incapacitated. That can include paying bills, managing bank accounts, dealing with taxes, speaking to financial institutions, handling property expenses, and in many cases even selling a home if it becomes necessary. The word durable is not decoration. It's the difference between a document that works when you're healthy and a document that works when you're incapacitated. Many people sign a basic power of attorney and assume they're protected. But a standard power of attorney may stop being effective when you become mentally unable to make decisions, exactly the moment your family needs it most. A durable power of attorney is designed to continue. Here's the most dangerous myth seniors believe. my spouse can automatically handle everything, or my adult children can step in if I can't. In many situations, that's not true. Banks don't have to accept family, they accept signed authority. Even when the intention is good, institutions often refuse access without the proper paperwork. That's why the Consumer Financial Protection Bureau warns that without legal authority, families can be forced into guardianship or conservatorship, processes that are expensive, slow, stressful, and public. And one more important point, Social Security benefits are a special category. A financial power of attorney generally does not give someone the authority to manage your Social Security check the way people assume. Social Security has its own process, including the concept of a representative payee. The SSA also allows something called advanced designation, where you can name people you trust to serve in that role if it's ever needed. The reason I'm emphasizing this is simple. People assume one document covers everything. It doesn't. A durable financial POA is essential, but it's not a magic key for every agency. It's still the foundation. The second document is a last will and testament that clearly addresses your home, not just a will. A will that specifically says who inherits the house and what should happen if that person dies before you and how disputes should be handled. Because here's another myth. Everyone knows what I want. Knowing is not the same as having legal proof. Conversations fade, memories change, new spouses enter, old grudges resurface, and once you're gone, you can't correct anyone. Without a will, your home is distributed based on your state's intestate laws, basically a default formula. Sometimes that formula matches what you would have wanted. Often it doesn't. Even when it does, the process of proving ownership and transferring title can become slow and expensive. Probate timelines can stretch many months to over a year, depending on the state, the court, and whether anyone contests anything. And the bigger the asset, like a home, the more tempting it can become for conflict. This is also where tangled title problems happen. A child may live in the home, pay the taxes, maintain it, even renovate it, yet still not legally own it. That can block refinancing. It can block selling. It can block insurance approvals. It can create messes that last for years. So yes, a will matters. And if you already have one, don't assume it's still correct. Major life events make old wills dangerous. Divorce, remarriage, a death in the family, estrangement, a child developing addiction issues, the birth of grandchildren, the purchase of a new home, moving to a new state. A will written in the wrong season of your life can produce the wrong outcome when it's finally needed. The third document is either a transfer on death deed in states that allow it, or a revocable living trust when a TOD deed isn't available or isn't enough. This is where many homeowners say, "I've never heard of that." Exactly. And that's why families lose months, sometimes years, after a death trying to fix what could have been clean and simple. A transfer on death deed, sometimes called a TOD deed, is a document you record with your county that names a beneficiary to receive the home when you die. While you're alive, you stay the owner. You keep full control. You can sell the home, refinance, change your mind, revoke the deed, whatever you want. But if it's set up properly and legal in your state, it can allow the home to pass outside of probate directly to your chosen person. If your state doesn't allow TOD deeds, or if your situation is more complex, a revocable living trust is the more flexible tool. A trust allows you to place assets into the trust during your lifetime, keep control while you're alive, and name a successor trustee to step in if you become incapacitated or after you pass away. But here's the trap that burns people. They pay to set up a trust and never transfer the home into it. A trust only controls what is titled into it. If the deed is still in your personal name, the trust may not prevent probate for the house. You can spend thousands on the structure and lose the benefit because the house was never retitled. This is why a trust must be properly funded and maintained. And it's also why people should be careful about trust mills, high-pressure sales operations that target seniors with expensive packages that may not actually be tailored to their state's law or their real needs. Now there's another layer people need to understand here: long-term care and Medicaid estate recovery. Many states are required under federal rules to pursue recovery from the estate of a Medicaid beneficiary for certain long-term care costs, especially when benefits were paid after a certain age. This can involve claims against the estate, and in many real-life cases, the home becomes the primary asset exposed after death. The exact rules vary by state, and there are important protections. For example, many states can't recover while a spouse is still living, and there are protections involving minor children or disabled children. But the big point is this: transferring a home incorrectly can create Medicaid penalties, and leaving a home unprotected can create recovery exposure later. That's why any decision to transfer the house should be done with full understanding of both probate and long-term care rules in your state. The fourth document is an advance healthcare directive, often including a healthcare proxy and a living will. This is the document that protects your body, not just your bank account. A financial power of attorney covers money decisions. It does not automatically cover medical decisions. An advance healthcare directive typically does two major things. First, it names someone you trust to make healthcare decisions if you can't speak for yourself. That can include choosing doctors, consenting to treatments, making hospital decisions, handling care facilities, and advocating for you when you're unconscious or cognitively impaired. Second, it records your wishes about life-sustaining treatments, things like ventilators, resuscitation, feeding tubes, dialysis, end-of-life comfort care, and other interventions. Here's what happens when families don't have this. In emergencies, people argue, not because they're bad people, because they're terrified and grieving and trying to do the right thing. One child says, "Do everything." Another says, "She wouldn't want that." A spouse says one thing. A sibling remembers another conversation. Hospitals need decisions. Time passes. When there is no directive, families can end up in legal conflict at the worst possible time. And in some cases, courts get involved. Also, a directive in a drawer is nearly useless. Your doctor needs a copy. Your hospital should have a copy. Your healthcare agent needs a copy. One additional trusted person should know where it is, because emergencies don't wait for filing cabinets. There is also a practical benefit. Medicare generally recognizes advanced care planning discussions, and many people can discuss these decisions during wellness visits. The key is to actually do it and document it. The fifth document is the one most people don't think of as a legal protection, but it can protect your home and your family in two ways: saving money annually and preventing a major tax mistake. This one includes two parts depending on your location and situation. One part is your homestead exemption and/or senior property tax exemption application, or property tax freeze programs where available. Many areas offer property tax relief programs for homeowners, seniors, disabled residents, veterans, or low-income households. These programs can reduce taxable value or cap tax increases. But here's the catch. In many places, they are not automatic. You must apply, you must meet deadlines, and some programs require renewal. If you miss it, you pay full tax year after year. Over a long retirement, that can become thousands you didn't need to lose. Now here's the second part of Document 5, and it's the hidden tax trap that destroys inheritances quietly. It's the difference between gifting your house while you're alive versus letting your child inherit it after your death. Many parents think they're doing something helpful by adding a child to the deed or transferring the home early to avoid probate or make it easier. Sometimes that decision creates a tax disaster. Why? Because of cost basis. If you gift a home while you're alive, your child often receives your original cost basis, what you paid for the home plus certain improvements. That means when your child sells, capital gains tax is calculated based on the difference between the sale price and that old basis. Example, you bought the house decades ago for $50,000. Today it's worth $400,000. If you gift it, your child's basis could stay around $50,000. If the child sells for $400,000, that's a $350,000 gain, potentially a massive tax bill. But if your child inherits the home after your death, IRS rules generally allow a step-up in basis to the fair market value at your death. That can dramatically reduce or even eliminate capital gains tax if the home is sold soon after. That one choice, gift versus inheritance, can be the difference between your child keeping the value of the home or losing a major portion of it to taxes. And that's why, "Just put my kid on the deed," can be one of the most expensive pieces of advice seniors follow without understanding the consequences. This is also separate from the home sale exclusion rules for primary residences, which can allow many homeowners to exclude a large amount of gain when they sell their own home, depending on meeting residency requirements. But those rules don't automatically protect your child's tax situation when you transfer the home to them. So the smartest approach is simple. Before you transfer your home to anyone, talk to a qualified estate attorney and a qualified tax professional who understands basis rules and your specific goals. Now, you've heard the 5 documents, but knowing them doesn't protect you, filing them does. So here's what I want you to do this week in plain steps. First, sit down with a piece of paper and write these 5 items. Check off what you already have and circle what you do not have. A durable financial power of attorney, a will that specifically addresses the home, a transfer on death deed, or a properly funded revocable living trust, an advance healthcare directive with a healthcare decision maker named, your property tax relief applications, homestead/senior exemptions, and a plan to avoid the gift versus inheritance tax trap. Second, for anything you do have, verify it's usable. Is it signed correctly? Is it dated? Is it witnessed, notarized as required in your state? Is it updated for your current life? Does the person you named still make sense? Third, don't hide the documents. Put them where they can actually work. Give a copy of the financial POA to the institutions that will require it. Give a copy of the healthcare directive to your doctor and your healthcare agent. Make sure at least one trusted person knows where everything is. Fourth, revisit this once a year. Not because you're paranoid, but because life changes. People change. Trust changes. Health changes. Laws change. A document is not a one and done. It's a living shield that needs to match your real life. One last thing before I let you go. If you're watching this and thinking this is overwhelming, I understand. But the truth is, the crisis moment is far more overwhelming. The paperwork feels heavy now, but it feels unbearable when you're trying to do it from a hospital hallway. These documents don't help after the emergency happens. They only work if they exist before it's too late. If you want, tell me your state and whether you're married or single, and I can rewrite this script more specifically, still without names or links, and include which of these options are most common in your state, especially the TOD deed versus trust part, because that's highly state dependent.